the study of fundamental right, the right to good administration. And in order to do that, we have among us Professor Emilie Chevalier, who is Associate Professor at the University of Limoges. She is an expert in European administrative law and in environmental law as well. She has published extensively on these two wide topics, and in particular, she is the author of a book on the principle of good administration in EU law. So she is truly an expert in the topic we are going to deal with. So besides all this, she is a good friend of mine. So this is another noteworthy characteristic of Emilie. And well, thank you very much, Emilie, and you have the floor.
Yeah, thank you very much. Thank you very much, Luis, for your kind invitation, and thank you very much to welcome me today. I'm very glad to be here. I must also say that I'm very glad because in September I just got new position at the law faculty in Limoges. I'm the vice dean in charge of the international relationship, and I just discovered that Limoges has an agreement with the University of Castilla-La Mancha, an Erasmus agreement. So I will be glad to welcome students, coming from university here, and also professors, and I would be glad to develop our exchange in those area. So today I'm going to talk about the EU right to good administration in the perspective of the obligation imposed on national authorities. We can. As Luis told it, I did my PhD. I finished the PhD in 2010, and the topic was good administration and the EU towards a European administrative space. And my PhD was then mainly focused on the European perspective. I dealt a bit with the condition of enforcement of good administration at national level, or on the consequences of this promotion of good administration at national level, but mainly it was from a European perspective. After the PhD, I kept on researching on this topic, and mainly on European administrative law. And at that time, I must say that in France it was quite original, since when I talked about my topic with colleagues, with scholars, they were just saying that European administrative law does not exist because according to them, administrative law could only be the law of a state. And since the European Union is not a state, you cannot have administrative law. So luckily, this view is not the official one anymore. And we manage with many scholars developing this idea that European administrative law exists. But this is something quite original, according to me, because this is not an homogeneous corpus set of rules of administrative norms, but it's more basically the law applicable to the administrative enforcement of EU law, meaning that European administrative law is made from both European rules and national rules, and you have this kind of coexistence and also a duty of interactions between EU level and national level. So it's, of course it's a law with a content, but I would say it's more a law about principle of articulations of interaction between legal orders. So that's why I'm quite interested in this. So my research are much dealing with the influence, classically, with the influence of EU law on national administrative systems, sometimes with a comparative perspective to notice the convergence existing between member states because of EU integration. But also more recently, I got also interested in the development of new forms of administrative actions because of EU integration, and that's at this occasion that I met Luis, because we are part of a network on transnational administrative law. And this is something I think quite interesting, because nowadays administrative authorities are obliged to work in a different ways, or to cooperate among each other and to exchange information, to exchange data, and you have new issues coming from these relationships. For example, the question of judicial review is also very central here. And so after this, I would say that I'm not an expert in a specific field. I'm more interested in environmental law because Limoges is quite known for environmental law, but I take environmental law, migration law, data protection law, much as a field of analysis, how administrative relationships are organized. So yes, my work is more about administrative relationships. So today I would like to talk about the research I'm doing on good administration principle and the question of enforcement of Article 41 of the Charter at national level. So this is now what I'm dealing for some months, some years. We can assume that there is no real issue here, or that the answer to bring to this question is quite easy. Why? Because, as you may know it, Article 41 of the Charter recognizes the right to good administration, and we know that all the rights mentioned in the Charter of Fundamental Rights have also the rank of EU general principles. And we know that EU general principles have to be enforced, have to be respected by national authorities when applying EU law. So apparently there is no issue. Nowadays the case law of the Court of Justice widely developed the meaning of good administration, and so national authorities should be bound by it. However, if you look at the case law of the Court of Justice and of the national judge, and here mainly of the French administrative judge, it's quite interesting that this question, the field of the good administration is quite sensitive, actually. What is it about? Good administration is about setting procedural standards in the administrative relationship, like the right to be heard, duty to give reasons, access to files, etc., etc. So it's about what kind of guarantees should be awarded to an individual when he will be the object of an administrative decision. And as I will explain it, this question was not an issue from the EU law perspective, because when you study EU law, when we explain to students what is the system of competencies and division of competencies between member states and the EU, we focus on the legislative competencies. We don't focus on the enforcement competencies, like the executive competence of the EU. And I would say that after decades of European integration, this is now a big issue, because there has been an increasing awareness of the importance of the executive stage, of the enforcement stage of the EU. Okay, it is something, of course, which is absolutely necessary to set up general principle to make sure that all the national system will work according to the same general principle. But we became aware that I don't know what is the exact translation in English, but in French, the devil is in the details. So it's not enough to say that we have common general principle and after everything will be common. No, at the administrative stage, you have differences, and these differences could have huge consequences on the condition of enforcement of EU law. So this is why I'm particularly interested in this topic, because, yes, this is something looking like secondary. Research mainly focuses also on the judicial enforcement, for example. We don't focus on these purely technical things, but nowadays, yeah, we become aware that it could be more and more important. And we can also mention that there is now some discussion about the possibility of leading an harmonization process of administrative procedure at EU level. So these discussions are still in course. I mean, they used to be more on the agenda a few years ago. I would say now EU has something else to do than dealing with this kind of issue. But yeah, we could also question the interest of such harmonization process of administrative proceeding at national level. Yes, we can go to the next slide. First, I would like to explain you why is it such a sensitive issue. Why this purely technical field is very sensitive, appears to be very sensitive for the EU and for the member states. So the area of administrative proceedings has not been the object of a general process of harmonization. Why? Because the EU was based on the principle of an indirect administration, meaning that, as a matter of principle, EU law should be enforced at national level according to national procedure. Many reasons justify this choice, especially because at the beginning of the European integration process, there was not, enough resources, like human resources, financial resources, to set up EU administration in each member state. So the system is the following one. The legislative process is led at the EU level, and the executive process will be up to the member state, each member state individually. So this is based on the principle of procedural autonomy. Consequently, there is no general EU competence to deal with the question of administrative proceedings. So you see, we are entering a field where EU is not supposed to come. But as you may imagine it quite easily, this is not the kind of things which stops EU, for sure not, but the way to come in this topic or to deal with this topic cannot be really straightforward, but will be more like this, like more or less a snake. So let's look at the treaty and let's search for a competence for EU action in this field. Some people mention Article 298 of the TFEU. So this article, this provision is the one which say that the European administration is based on the principle of openness, transparency, etc. So this provision is about administration of EU, not of national administration. So, according to me, this provision cannot be relevant to ground a general process of harmonization of national law concerning this question. But some scholars, propose to have some extensive view of Article 298, but okay, according to me, it would go certainly too far. Another competence which could be used, or we may think about, is the subsidiary competence, provided by Article 352 of the TFEU. This is the provision which say that if the EU needs to intervene in a certain field and the treaty did not provide explicitly for competence in this area, unanimity decision of the Council can decide that the EU could intervene in this field. And in this case, the exercise of competence should be in line with the objectives of the EU. So we may imagine that we could use Article 352 because we know that if we invoke internal market, maybe we can do whatever we want and it will work, to fall within the scope of Article 352. I would say that, according to me, the main obstacle here is the unanimity decision. I can imagine only with difficulty that all the 28 member states still would agree to have such an harmonization process, or it will lead to something with very low standards, so not very, I would say, useful, but we can discuss this afterwards. So the first solution, and this is, I stop the suspense, but this is the solution we have. This is the implied powers. So the notion of implied powers refers to the thing that we will recognize a special powers to EU when such a power is necessary to achieve a competence of the EU. And this reference to the implied powers has been developed or used to be developed with regard to to sanctions in environmental matters, because there was no power of sanction awarded to the EU in environmental matters until the Lisbon Treaty, and so before the EU wanted to adopt such a legislation, and they referred, the Court of Justice referred to this kind of power. So you see that we will allow the EU to adopt legislation in administrative proceedings because it would be necessary to increase or to ensure the effectiveness of EU substantial law. So we can see here that administrative guarantees are considered or could be considered as a way to ensure the effectiveness of EU law. And according to me, this is the right way of doing things. Just to remind you, classically, the administrative procedural guarantees have two functions, or we present it for two functions. First, the instrumental functions, meaning that we recognize administrative rights to people, to individuals, because it is needed for administrative authority. I will give you an example, and maybe it will be clearer. Through this perspective, we recognize the right to be heard, so granted to individual before being the object or before decision will be adopted and concerning his situation, because the administrative authority needs to have information, and the individual here is considered as a source of information for administration, for the administration. So this is the instrumental function, because here we stress the utility of the individual. The other conception of administrative right is what we call the dignitary function, and this is to say that administrative rights should be recognized to individuals because they are fundamental rights, full stop. We don't look at if it is necessary, if it is useful or not for the administration, but individuals have dignity, and we should recognize to them fundamental rights. This is the conception with Article 41, recognizing good administration as a fundamental right. What is the interest to mention these two perspectives with regard to procedural law or to procedural administrative law? The choice for one theory or the other has consequences on the interpretation of the rights. For example, if you do consider that we just follow the instrumental function or the instrumental conception of right, this means that administrative authority would be able to limit those rights because we need to ensure the effectiveness of the functioning of administration. However, if we do consider that they are fundamental rights, the limits which could be brought to them will be much more strict. It will be much more difficult for the national authorities to do it. Saying that, as I told you, so the way of implied powers is the one which is used at the EU level, and nowadays we see more and more, we find more and more in the directives mainly, provisions related to procedural requirements which are applicable at national level. But here you see the big difference with what I said before. This is not a general harmonization process. This is a sectorial harmonization process. Sector by sector, directive by directive, you have standards, administrative standards, which are set up. In addition, if you look at this, the harmonization is very soft, because if we look at this provision, it's the references are very wide. Like, for example, you have provision in asylum directive saying that it is necessary that due process would be respected by national authorities. Of course, this notion of due process means something for the member states. It's part of the traditions of the member states. But here again, the devil is in the details. I mean, of course, it's nice to say that you respect due process. But the most important afterwards is to know, okay, what kind of person are going to be heard? When are they going to be heard? Are there possibility to challenge the decision before the administrative authorities? What is the extent of the duty to give reasons, for example? Yes, surely, I mean, all the member states have this kind of requirement. If I'm not wrong, in Spain it's even in the constitution. In France it's not the case because we have quite a different conception towards this. But the thing is to know how it works practically, concretely, to know or to check whether due process or whether the guarantees are effective. So we have this kind of intervention from the EU, referring to due process, referring to duty to motivate or whatever, but this is very vague. So surely here we needed some intervention from the Court of Justice to know about the details, more or less. But as you may see it, and as I may explain it, it's not so clear. Or I must say that I'm not sure that the intervention of ECJ was bringing more clarity. So if now we focus more on the question of enforcement of EU good administration principle at national level, the first question we should solve is the question of the organic scope of good administration principle. Organic scope so refers to what kind of authorities are bound by this good administration principle. Why is it an issue? Because if you look at the wording of Article 41 of the Charter, here you can see that the problem is set up. I read, every person has the right to have his or her affairs handled impartially, fairly, and within a reasonable time. Okay, this is easy, this is the basic rights included in good administration. The problem is coming after, by the institutions, bodies, offices, and agencies of the Union. So clearly, Article 41 of the Charter hopes for a strict scope of application of the provision, limited to the EU administration, strictly speaking. So, why am I not question this? Because if you look at the other provisions of Title 5 of the Charter dealing with citizenship, we have also this restriction with the right to vote, for example, with the right to to go to the ombudsman or to access to documents. We have this restrictive scope, and this can be explained because it's about EU citizenship and not national citizenship, for example. But the problem is that the scope is in contradiction with the classical organic scope of general principles of EU law. As I told it in the introduction, every right of the Charter is also or has also the rank of the quality of a general principle of EU law. And with regard to this principle, the scope is much wider because it applies to European administration, but also to national authorities, including national administrative authorities, when enforcing EU law. So, what to do now? Either to stick to Article 41 or to stick to the ECJ case law and the wide scope of EU general principle. So some scholars said, okay, maybe Article 41 is kind of lex specialis, and which justify to derogate from the classical scope of EU general principles. So here, mainly, here we needed really intervention of ECJ. In the next slide. So, need for enlightenment from ECJ, especially ECJ case law, which was developed following preliminary ruling. Okay, you got it. Preliminary ruling and made by national judge, but concerning mainly UK and France. We had a lot of cases. Concerning France, so showing that it's quite an issue. And so maybe the question I have is more because I'm from the French system, and here in the French system, the notion or the weight given to the procedural rules are really limited. So maybe, okay, this may explain this. The first case which came was the case of December 2011, the Chicala case. Clearly here, the court, as I quoted it, stated that Article 41 of the Charter does not apply to the member states, okay? It's a strict, literal interpretation of Article 41. Okay. Another case, almost 1 year later, so in case adopted in November 2012, the M case. Here, in this case law, the court considered that the right to be heard is very important. And it has to be respected when EU law is applying, okay? So here, apparently, in this case, ECJ opts for a much wider scope of the good administration principle, the right to be heard, and consider that it could be also applied to national authorities. However, in addition, the last paragraph is very important. In accordance with the court's case law, observance of that right is required even where the applicable legislation does not expressly provide for such a procedural requirement. So this is the main object of the general principle of EU law, is to fill the lacuna of the text. Okay, a text did not provide for a specific guarantee, but now you can claim for the application of the EU general principle. So the M case brought some troubles. Okay, do we have to stick to Chicala, or do you have to opt for this new solution? A last case I would like to mention you, so was given also in 2014. So YS, so I think, yeah, this was a case against the Netherlands, I think. And here again, you see that the reasoning of the Court of Justice is not clear at all. Because in the first paragraph, the Court of Justice repeats this idea that Article 41 does not apply to national authorities. If you look at the second paragraph, it is true that the right to good administration reflects a general principle of EU law. So you see that the Court of Justice used both charter but also the unwritten ground. And I think the interest is for the next sentence. However, by their questions in the present cases, the referring courts are not seeking an interpretation of that general principles, but ask whether Article 41 of the Charter may in itself apply to the member states of the European Union. So here, and if you read the case, it's quite evident, the Court of Justice say more or less, okay, if the national court asks for the application of the general principle of good administration, I would have said, yes, it applies to national authorities. But here, sorry, the national judge asked only for the application of Article 41. And here, I'm saying, no, Article 41 does not apply. And I must say, this kind of case really, surprised me, because when we know, how the Court of Justice has the power to regulate the relationship between the court itself and the national judge in preliminary ruling procedure, and the power to rephrase the question and to make sure that the question would be admissible at the end of the day. It's clearly, in this case, a way for the Court of Justice. I really don't want to deal with this question, because, of course, I have my case law, but I have the charter on the other side, and the charter was more or less written by the member states. So what to do? Going against the member states, or going through the case, sticking to the case law. And this here, I think this kind of position is due to the fact that EU has no competence in this field. So it's very hard for the Court of Justice to say that, okay, let's go for harmonization process of administrative proceeding. It has no legitimacy. And clearly, it's up to the member state to determine the standards. And if we look at the case law, so there are some 10 or 15 cases, of the Court of Justice dealing with this point. We can see that this decisive point, and which may also explain the difference of solutions developed by the Court of Justice, is the existence or not of secondary law provisions providing for administrative requirements. And this is really the case in asylum and migration cases, where we can see that if the Court of Justice can first refer to a provision of secondary law saying that national authorities have to comply with due process, for example, general principle of good administration will be applied and will be considered as fully applicable and as to be respected by national authorities. On the contrary, if the applicants just claim for the application of the right to good administration or the principle of good administration without mentioning a secondary law provision, the Court of Justice would say no application of principle of good administration. So this is really according to the first intervention or not of the legislative power at EU level, which would legitimize or not the Court of Justice to impose new standards to administrative authorities. And I must say this way of doing is very strange. And I must say that a few years ago, I made this kind of contribution in a Congress, and there was a judge from the Court of Justice, and he did not really agree with my interpretation, I must say. And he said, no, but it's normal. If the legislator did not intervene, we cannot do it. I said, okay, please just remind us Van Gunnen, Laws and Costa and whatever. When you want to do something, this is not a matter of the text of the treaty in any case. But you see, the Court of Justice has to review a bit of its case law in order to fit with the requirement of the Charter. So what is interesting also what are the consequences of this case law at national level? Because, so I studied mainly the French administrative judge case law, and maybe you are not aware of it, but the French administrative judge has been and is still to some extent quite reluctant sometimes to apply EU law or to give full effect to EU law, and especially when it is about the sovereignty of the Council of State. And the Council of State does not consider at all that it has to follow the principle set up by the Court of Justice. At the end of the day, it works. But this is always the idea that it's not because EU law says that, but it is because French law authorized to do it. This is, yes, the result is the same, but the ways of doing it is quite different. And you may imagine that the uncertainty brought by the case law of the Court of Justice could have been considered by the French administrative judge as a kind of highway, to do what they want, more or less, with these guarantees coming from EU law. And I would say that from 2012 to 2015, the case law was quite chaotic, I would say, from the French administrative judge, and sometimes they refer to Article 41, sometimes they refer to the principle, sometimes they say, no, French administrative authorities are not bound by Article 41. Okay, we can assume that it doesn't really matter because we will then refer to the national conception of procedural rights. But as I will explain it now, we are here dealing with case law in a field, in very sensitive field, which is migration case. And of course, you will understand very easily now that migration cases are not really the cases where the fundamental rights are the mostly respected in the French administrative system, but I think it's more or less the case in other administrative systems. And because of the amount of demands, of the amount of claims, brought by migrants, in order to get asylum or in order to challenge the refusal of a permit of residence, of course, the administrative authority has to deal with many claims. And in this kind of situation, fundamental rights are not the wide priority of the national authorities, and we will see now. So this is, just a case. You can go through because it was in French, so nothing. So I will finish by explaining this, that another question about the enforcement of Article 41 of the Charter is what are the level of protections? The level of protection granted by Article 41 and the good administration. Indeed, good administration is part of what we call the undetermined notion. It's called the standard notion. So this is the notion which has to be interpreted by the authority which will be in charge to apply it, of administrative authorities, legislator, judge, or whoever. Good administration means nothing as such. It just refers to a kind of average behavior, top behavior from the administration. Okay, it all depends on the conception you have. So here again, the ECJ case law was much important in order to define what is the level of standards of good administration. Let's take, for example, the right to be heard. The right to be heard can be enforced in many different ways and in many degrees, of effectiveness. You can say that the right to be heard would be granted if an individual asks for. Okay, this is the lower level, the lower degree of protection. You can say that an administrative decision will be annulled if the right to be heard is not respected. And this is another degree of protection. Or you can say that, in any case, you know, individuals can claim at any time for the right to be heard during the decision-making process. And it's even another degree of protection. So you have many options. So here again, the ECJ case law was very important, knowing that ECJ was really interventionist, was really ambitious when setting the level of standards applicable to EU administration. You have much case law, and that's why I studied more or less in my PhD, the case law of the Court of Justice on the reviewing the Commission decision. And in this context, in competition law, for example, in trade or this kind of direct administration matters, the Court of Justice was really ambitious, asking for, imposing to the Commission more and more standards, more and more obligation. Okay, this does not mean that the Commission is very strictly limited when adopted such decision, but surely, you know, this development of the right of the good administration has widely beneficiated to the individuals. But here, and you can see that it can also be explained by this question, this matter of division of competence. Here, when the ECJ has to deal with the definition of standards of good administration at national level, the option was a pragmatic conception. And pragmatic here, I mean restricted, of course, conception. By its case law, the Court of Justice recognizes a wide margin of discretion for national authorities. So, more or less, the Court of Justice just say, okay, right to be heard has to be respected. But after the details should be determined at national level. And the Court of Justice, through its case law, and the case law is quite clear to this respect, so the Court of Justice accepted that the national authorities could balance the interest at stake, meaning that, of course, on one side you have the right to be heard, on the other side you have the effectiveness of administrative process, and the need not to give too much work to the administrative authorities, and you need to balance. So, of course, the right to be heard has to be respected, but it should not be an obstacle for the administrative work. And so I quoted some case law. Yes, one of the main interesting case law is adopted in November 2014, Sophie Moukarou-Bega. So it was a case referred to by a national judge, an administrative court in France. So you see the reasoning, consequently the obligation to adopt with respect to third country nationals. So this is the enforcement of what we call the return directive. So the directive which set up minimum requirements to be respected when individuals have to be deported or exposed to their member states of origin. So the Court of Justice recalled that the requirement of fair and transparent procedure, but we see it's very general. Member states must, and this is here interesting, within the context of their procedural autonomy. So the court here recalls, okay, this is not a competence from the EU, the principle of procedural autonomy is applying. And here, the Court of Justice tries to make some guidelines, you know, when enforcing the right to be heard. They say that, of course, it means that the individual should be heard before leaving the territory, which is the basic, of course, and also that this right to be heard should be granted in any procedure of this kind, in order to challenge the legality of the state. Nevertheless, and it's here that it's quite interesting, the right of defense do not constitute unfettered prerogatives and may be restricted. So this means that, of course, the Court of Justice said, okay, you have to respect right of defense, but you are also allowed to restrict rights of defense. And if you keep on the reading of the paragraph, you will see that here the national authorities have a wide margin of discretion. And now, with the next slide, you will see the result, how the French administrative judge applied this case law. So I will put it in French, but I will try translated, of course. So what I would like to show is that the ECJ, the case law of ECJ just opened the door, you know, for a very narrow conception of administrative procedural right. So it says here in this case held by the Administrative Court of Appeal, so in 2014, that the obligation to comply with the right of defense is an obligation imposed on the member states because they are enforcing EU law. However, it's up to each member state to determine, according to the principle of procedural autonomy, in which condition the right to be heard should be ensured. So here, clearly, the administrative judge just say, okay, we are going to decide at national level what kind of standards, what the level of standards we are going to apply. And what is quite interesting here, the administrative court says, so the competent administrative authority, the prefect in this case, has not the obligation to give the opportunity to the person to submit his observation. So I must here be more precise with regard to the procedure which is applicable in France with regard to the expulsion of migrants. So the idea is that, I mean, the proceeding is the following one, okay? The person, the individuals wants, I mean, first applied for asylum, okay? And most of the time, he just become a refusal. And after, he applied for a classical a right of stay, a permit of stay, and then this permit of stay could be also refused. So, in this case, the migrant can be expulsed. And so the core question was to know whether the administrative authority has to reheard the person before expulsing him or her. It's complicated. Before expulsing him or her. And here the judge say, no need. Because when the individual applies for the residence permit, he already had the opportunity to express his view. Now, a new decision is adopted against him, a decision of expulsion, but it's too late. There is no chance for the individuals to present, to introduce new observation. And so the justification of the French administrative judge is to say that, and you will see the spirit of the words, to say that in any case, the migrant will be able to challenge the decision of expulsion before the administrative judge, and he will then be able to submit new observation. So this is really the French conception of administrative procedural rights, that, okay, of course we recognize them, but sometimes, due to the workload of administration, we will not be able to respect them at the administrative stage. But it doesn't matter, since at the end of the day you will go before the judge, and the judge will be able to respect them. Okay, this was the position you could have in the 60s or 70s. But nowadays, this kind of position is not acceptable anymore, because it's just to say that you don't care about the administrative stage. You don't imagine that maybe if you respect procedural rights at the administrative stage, it will be a way to avoid a judicial process. It will be a way to avoid judicial review, because the right decision will be adopted. But this is not at all the French conception of administrative procedural right, and it's also because of this that procedural rights are not recognized at all in the Constitution. And they are just mentioned more or less in the legislation, but they are mainly developed through administrative general principle of law, which are just above administrative act, but they are below legislation. So this is to say that it's not so important because the judge will come afterwards. So we are here very far from Article 41 conception of the Charter. So, and this is, okay, we can skip because this is more or less what I said, yes. Sorry. Yes, I wanted to finish with this, that these migrant cases are quite sensitive, and you can see it because of the reaction of the administrative judge. And you can see that there is almost mistrust or distrust from the French administrative judge towards ECJ in this context. I explain. What I quoted here in French, is a comment made by a French administrative judge called Marc Clément, someone I know and is very nice apart from this. So he's a judge at the Administrative Court of Appeal of Lyon, which is very important for migrant cases due to geography, spatial scope, of the court, because migrants coming from Italy are just dealing with this part of the territory, of course. So they had to deal with a lot of migrant cases. And here in this paragraph I quoted, so this was a paragraph which was published on the official website of the Administrative Court of Appeal. And in this paragraph, the administrative judge said, first, we just interpret how we want administrative standards. Because of procedural autonomy, it's up to national authorities to do it. And second, he said that ECJ has nothing to do here, because it's up to the member state to decide. And they say that they have no obligation to use preliminary ruling, and they have no obligation to comply with preliminary ruling decisions. So you see how the field is very sensitive, because to have these kind of things really, made public, it's ready to say, okay, that first we don't care about EU law and we don't care about ECJ. So this does not mean, of course, that French administrative judge will not comply in the future with ECJ case law or whatever, but this means that in this specific area of procedural rights, no way, no competence of the EU, no legitimate intervention of the ECJ. So to conclude, we can see that there is certainly some space for improvement in this field. And of course, we can ask the question of the need for harmonization of administrative procedural law at EU level. I must say that I'm quite against this harmonization process. It could seem quite strange because of what I said before. A general harmonization process, according to me, is not so useful because, in any case, if you look at the national legislative act dealing with procedural requirements, you are just very general. You say, what do you say? Due time, right to be heard, impartiality, fair treatment, etc. So I'm not sure that it will bring something more than the current set of EU general principles. And I would say that at this stage of European integration process, maybe we need more subsidiarity in any case. And maybe we say that, and we should accept that, procedure has something to do with the member state traditions. And maybe we don't need to harmonize everything. I know that someone here works on the ARIS enforcement, implementation, and access to national judge. Here again, we don't have any harmonization legislative process. But it works, of course, it doesn't work perfectly, okay, we have some obstacles, but let's imagine how many judicial decisions you have in this field, and so little number of cases you have at least before the ECJ. So sometimes harmonization maybe is not always the good solution. So in the future, I would like to keep on with this research. I would like first to work more at national level and to compare national solution, because I would like to assess the impact of diversity on the effectiveness of EU law, specifically in migrant cases, so to do more comparative enforcement administrative law. And I would like also to go further with my analysis in other areas of EU law, because I have the feeling that this withdrawal from the Court of Justice, or this shy interventionism of the Court of Justice could be also explained because we are dealing with migrant cases and because they are very sensitive, of course, for the member states. And I will finish with the last slide and with a case of the Court of Justice held in December 2015, and it's a case which deals with tax law. And you see with this case that in this field, the Court of Justice does not hesitate at all to intervene. And you see, even if the EU legislation applicable does not expressly provide for such a procedural requirement, meaning that in tax law, even if secondary legislation does not say anything, the Court of Justice say, no, you have to apply the general principle of good administration without any doubt. So, you see, there is this question of competencies and there is also this question of field. And I think it would be interesting to go, to proceed further or to do further investigation in this topic. Thank you.
10 minutes, so if anybody has any question or comment, the floor is open for you all, so feel free to... Adam and Isaac.
Yeah, thank you. I thought that was really interesting. Many of the things that you say, at times I think you perhaps underplayed the significance. Certainly the general principles of the EU law, I think they are really fundamental. The one which you perhaps didn't mention was sincere cooperation in Article 4.
That's true, yeah.
Which is absolutely fundamental in respect to precisely
That's true.
Point, the very last point that you made, that member states have this positive duty in the administration of EU law to ensure that they remain compliant and that they ensure that the rights are available effectively. So I think there's a lot to say for the general principles. And I think that's sort of the second point that I would make, sort of leads on from that, is procedural autonomy. And maybe this is just a debate that we've had in the UK. But many European lawyers have sort of taken the view that procedural autonomy is really a bit of a legal fiction now. Things like non-discrimination, effectiveness, proportionality, these are all ideas and principles which have taken over and really restrict courts with respect to what they can and cannot do in the application of EU law, but also it's had a spillover effect into English or UK administrative law as well, when you see those principles of EU law and administrative application coming back into the UK system. So the courts, the House of Lords previously has taken the view that if a right is available in EU law, it would be odd that it's not available in the wholly domestic context. And the effective remedy should be there. So I think that's important. But the final point that I would make is, and this is why I completely agree with you about this idea of effectiveness and enforcement of administrative law. Having spent the last 2.5 years looking at the Brexit process and what that means in terms of withdrawing from the European Union, where we end up with this rather strange concept of retained EU law, this law which would be in existence on the day that the UK leaves. So it's the acquis as it exists on exit day, which the UK will adopt. That is completely devoid of any effective enforcement. So there's nothing that underpins EU law, if you retain EU law in the same way that you have with respect to enforcement in courts, before the courts of justice. So you, for example, don't have rights like Franklin's right. State liability has gone. And I think this is where it's important to see that the principles which the court has developed, which may not necessarily be as explicit in the treaty, are really, really fundamental. They have had a significant effect. And I think they sort of created values and aims of administrative law, which aren't, or which cannot necessarily be written down.
I completely agree, and I think UK will be a very good example to see. I mean, what could be the difference? I mean, what could be the situation in a state, not in a member state, but in a state where you don't have this EU limitation. I don't think it will collapse or something like that, but it will be quite interesting to have this kind of example of a state sharing values with other member states, but to see whether, I mean, how the margin of discretion will be used or not. And yeah, this is not so sure that it will change, especially in the UK, because in UK administrative law, I mean, I'm not an expert, but we have this clause of due process, which is quite effective, I mean, to guarantee rights. And with regard to procedural autonomy, I completely agree with you, because, I mean, we know that this question of procedural autonomy is not maybe anymore a principle, basic principle, since it does not exist that much. You know, I don't know if you know this book written by Diana Oriana Galeta about procedural Paradise Lost. That's it, Paradise Lost, and she explained this. But I must say that I was even more surprised when I was dealing with this case law, because I said, okay, now we found a place where we still have, or we still use this old-fashioned procedural autonomy principle, because I think this conception of procedural autonomy has been, I mean, we mainly deal with it through the national judge and the limitation brought to the national judge. And we didn't deal so much with the consequences on administrative authorities. And I don't think they just, of course, here the Court of Justice claims for the effectiveness of EU law, but okay, I'm not sure it just applies in the same condition as before the judge.
Isaac?
Nothing to say, Professor Sagan has stolen my comment, so it was about procedural autonomy. Just maybe to say that Spanish case law, I mean, national judges are invoking right to good administration in order to apply some standards to national administrations as a source of inspiration. So there is no space for procedural autonomy with this kind of interpretation. That was a comment.
But it's also because, I mean, okay, I don't know, but I think in some regions you have it, no? The right to good administration is recognized in some regional statutes, no? Yes, that's it. So maybe you are more familiar. Because, for example, from the French perspective, of course, we respect all these requirements, but we don't use the good administration concept. Because from the French perspective, administration cannot do wrong. So it cannot be good as well. I mean, just administration. But this is really the point. You don't have any use of the word good administration. Even before the ombudsman, you don't care. I mean, no, because it's general interest. It runs for general interest. So it has not to be assessed. It does not have to be assessed. It can, of course, be infringing this principle and this principle, but you cannot say it's good or not. It's like the monarch, you know, and you cannot touch it.
Susanna, we have still 5 minutes.
Thank you very much for your very interesting and inspiring presentation. I learned a lot about Article 41 and the principles and the technicalities. My question is more vague than the ones that were posed before. Because I think this is a very good example, and I think the way you presented here shows that to take a particular example, to take a particular point or an article here, to think about constitutional dynamics in the EU. Actually, you have a constitutional discourse underlying your presentation. You say that at the very beginning, not really about contents. It is about contents, but it is more about the interaction or the interplay between institutions, different actors, and so on. I think during your presentation, you were actually discussing what the role of the different classical powers has been and is now. The legislature, the executive, and the courts, of course, the judiciary. And you said now more focus is put on the executive, but of course, really the king of the powers are the courts. Is the European Court of Justice and are the other courts, constitutional courts. Professor Arroyo knows a lot about it and has written about it, the play between constitutional courts and the European Court of Justice and ordinary courts. At a certain point, you were mentioning a case, the Minister from Immigration, and you said, basically the court didn't want to go into that particular problem, of course, because it does have a political role and it has been and it is very important. There is this book in France, maybe actually you were one of the authors, with the whole politique de la Cour,
Yes.
which is, I think, one of the key topics today. As I said before, I think this is a very good example, and the way you presented it to reflect on how the separation of powers actually in Europe, at European level, in Frankfurt in that sense, and also at national level, is somehow moving and is somehow different from what it was in the past, with of course a very predominant role of the Court of Justice and of the courts in general.
Yeah, I completely agree with you, but I must say that I mean, I have the feeling that, okay, maybe we are going to something, but something different and something we need to build, and that's why European law is so interesting, I mean, to research on, because you are not obliged to stay in the classical model, and certainly the classical notion of separation of powers is not relevant at all. I mean, we know that from the institutional organization, it was not really relevant, of course, but here again, we need to think about the articulation between national and European level, among national systems, because we have interaction also among national systems. But I think the most important now is to know or to be aware of who is the counterpower. I think this is the most interest of the separation of power. At the end of the day, if you have 2 free powers dealing with the same topic, okay, why not? And we can create what we want. But who is going to play this role of counterpower? And especially in this case of migrants, you just have the judge. Because you cannot count on the lobby, of course, you cannot count on the NGOs, or because we don't have, I mean, we have so much to do and not so many resources. It's not the same as in tax law, for example. I think in tax law, it's quite interesting because tax law is a matter of where the EU has no, has competence, but very strict competence, because it's really a matter of sovereignty, except for the VTA or TVA, or I don't know which order, the tax directives which are adopted. But here it's quite interesting because in this field, administrative cooperation is very, very much developed. And we could say no, but there is no point because there is no EU in competency. But here, on the contrary, it is very well developed. But I think in tax law, there could be like adverse power, or we could have a counter power. Or for example, also in environmental matters, it's okay. I mean, NGOs deal with this complexification of relationship between the systems, but not in all the systems. And now I think migrant cases are very interesting for this because they are very numerous because of the context. But yeah, it shows also the lacuna of the European system, and we know that it's also in the time of crisis that you really test your model, and hopefully it will manage.
Well, I will just make a final comment. Thinking in special in the Spanish students of EU and administrative law, because maybe they are not completely familiar with the notion of good administration and the content of Article 41. And the concept of good administration is like an umbrella within which we can find different pieces, different building blocks. And some of them are pretty known in Spain, such as the right to be heard, or the right to access to information which is in the hands of the public administration, or a right to be compensated for damages. And the impact of this right in national public legal orders might be different depending on how these national legal systems deal with all those particular issues. And from this perspective, the impact in Spain of the right to good administration might be not so spectacular in terms of the right to be heard, because we have a very developed and rich regulation of these procedural rights. Or it might not be spectacular neither in terms of the right to get a compensation for damages, because our constitution is very generous in this respect. But in turn, the consequences might be of great importance when we focus on the right to get administrative information, because the level of protection in Spain is not as generous as it might be. And in particular with respect to another content of the right to good administration, which is not a subjective right, but which is very important, which is the idea of sound administration, the idea of objectivity, according to which administrative decisions have to be taken after balancing and taking into duly consideration all factual and legal elements that are relevant for the decision to be taken. And what are doing national courts, national administrative courts, is using Article 41, or more broadly the principle, in order to demand procedural steps that are not compulsory according to administrative legislation. For example, impact assessments, which might not be compulsory according to the regulation of the procedure, are being treated as if they were compulsory under the invocation of the principle of good administration. And this is a development which is of great interest. In a very recent decision of the Supreme Court Administrative Law Division, which Susanna knows very well, the Supreme Court has begun to put some limits to this tendency by saying, well, if the legislative regulation of the decision-making procedure does not provide compulsory for a gender impact assessment, then you cannot claim that the administration is bound to the principle of good administration, and that taking into consideration the impact, the gender impact of a planning decision, for example, is required in order to comply with this first content of Article 41, Section 1 of the Charter. So there is this tension nowadays with among the administrative law courts in our country. It was just this note to close the panel. We will make now a short break. Well, it's not so short actually. 30 minutes, 25 minutes. We will be here at 5 to 12. 5 to 12.